Looking through the most important news from last week, majority of them are connected with one single idea, questioning the elements of democracy and the implementation of the governance in India. So, I always like to set apart the discussion of politics from the study of Indian polity. So, because of that reason, few of them had to be deliberately cut off from the discussion. But one single news, which was capturing my attention repeatedly for the past few months and also for years, and that is with respect to an ongoing case of the Supreme Court of India, the one in which the appointments of the Chief Election Commissioners and the Election Commissioners are being debated. Welcome to another episode of Weekly Current Affairs by Amrita IAS Academy. I am Manisham Nambiar, and today we will be discussing the current affairs from Indian polity. So, the last week repeatedly there was a news which was about the discussion which is ongoing within the Supreme Court of India. So, the Honorable Supreme Court of India is now examining a law which was passed by the Union Parliament, that is the Chief Election Commissioners and the Election Commissioners Appointment Act. So, what is happening now? Why are they debating on it? What are the constitutional provisions related to it? We need to know exactly what happened in India. So, for that purpose, to understand what happened, we need to know what the Constitution speaks about this particular matter. So, we will start from there. So, we will start from the Constitution, then move on to the judgment of the Supreme Court, then to the law passed by the Parliament, and then to the current case which is ongoing in the Supreme Court of India. So, this is the news from last week where it says that the Centre defends the CEC panel without CJI. So, let us look what the Constitution has to speak about this particular matter. So, it is part 15 of the Constitution which is dealing with the Election Commission in India. Article 324 deals with the appointment of the Election Commissioners in India. So, Article 324 says that the Election Commissioners shall be appointed by the Honorable President of India. So, according to the Constitution of India, the Election Commissioners shall be appointed by the President of India. That is the first thing, appointment by the President. Second thing, what number of Election Commissioners? So, the Constitution under Article 324 says that the number of Election Commissioners shall be determined by the President of India from time to time. So, be it 1 or be it 2, 3, 4, 5, that's up to the President of India to decide. Now, what should be their eligibility? Not mentioned. Now, when the President is appointing them, on whose recommendation should the President appoint them? There also the Constitution is silent. And Article 324 says that until the Parliament makes a new law, any law made by the Parliament, it shall be up to the decision of the President to determine how the members of the Election Commission shall be appointed. Or in other words, in 1950 when the Constitution of India was created, Article 324 said that Election Commissioners shall be appointed by the President. And the Constitution said that currently we do not have a mechanism for giving nominations. How these nominations shall be made? That will be determined by the President until a new law is made by the Parliament. So, that was how Article 324 was crafted. The ultimate power was given to the Parliament, and till the Parliament makes a new law, the power was given to the President of India. But what happened was that the Parliament did not make any law in that regard. After 70s of years, after 7 decades, Supreme Court had to intervene. So, this absence of a provision in the Constitution and absence of a law resulted in a system where the Election Commissioners were appointed by the President upon the recommendation of the Cabinet. But don't you think there is an issue there? Because Cabinet is part of the executive and Election Commission is the independent body who is supposed to conduct free and fair elections according to Article 324. So, there could have been some conflict of interest. That was the issue which was highlighted by Supreme Court of India. And that was the judgment of Anup Baranwal versus Union of India. In 2023, in Anup Baranwal versus Union of India, Supreme Court said that this particular silence by the Constitution has been misused by the Parliament. So, we are going to stop that. Now, we are going to make a rule. The Supreme Court of India said that until a new law is made by the Parliament, President shall appoint, but there is a condition. The appointment from the side of the President shall be based on the recommendation of a committee. A committee shall make a recommendation, and only based on the recommendation of the committee, President shall appoint. That was the condition put forward by the Supreme Court of India in Anup Baranwal versus Union of India. So, who all are part of this committee? This committee shall comprise of the Prime Minister of India. Good. A representative from the executive, the government. Now, the leader of opposition in Lok Sabha, that is a representative of the opposition party, so that a neutrality can be ensured. Now, one third entity, that is a neutral entity, Chief Justice of India or any other judge who is nominated by the CJI. A third party, a person who is neutral from the active politics. So that was the recommendation, that was a judgment, not just a recommendation. That was a judgment given by the Supreme Court of India in Anup Baranwal versus Union of India. So that major thing was existing as per the judgment of the Supreme Court of India, and to revert this particular judgment, to overcome the limitations placed by the Supreme Court of India, what happened? Parliament of India passed a law in 2023, the Chief Election Commissioner and other election commissioners appointment, conditions of service and the term of office act. So according to this particular act of the Parliament, now when the appointment is to be done, the appointment shall be done by the President. There is no change in that. But President shall make this appointment based on the recommendation of a selection committee. And this selection committee shall comprise of the Prime Minister, just like the judgment, leader of opposition in the House of People, that is Lok Sabha, just like the judgment. And the change from the Anup Baranwal judgment is that instead of the Chief Justice of India, a Union Cabinet Minister to be nominated by the Prime Minister was included as the third member. So instead of that neutrality element from the side of Supreme Court, now a new member who is a Union Cabinet Minister has been included. So there was the challenge made by many people. Previously, it was government plus opposition plus neutral entity. But now this was based on the judgment of the Supreme Court. Government, opposition, neutral entity. But now what is the issue? Government, opposition and again government. And since the committee is working on the basis of simple majority, when two members support it, obviously that decision has to be continued. So this is being challenged now. Can the Parliament of India overcome a judgment of the Supreme Court, and that too from a constitutional bench? Can they overcome by passing a law to that effect? That is the question. So now you have understood that why the case is being discussed in the Supreme Court, where they are questioning whether this third person can be a government representative instead of a neutral representative. That is the question in the case. But before going on to that details, let us discuss few more things. So just now we have said that the President may appoint an election commissioner, including the Chief Election Commissioner, based on the recommendation of the selection committee. But now through this particular act, a new provision was introduced. This selection committee shall get recommendations from a search committee, and the search committee is headed by the Ministry of Law and Justice and shall comprise of two other members not below the rank of Secretary to the Government of India. So a 3-member committee has been created, a search committee has been created to identify the most suitable candidates. So who are the members of this search committee? The Union Law Minister and two other members of the permanent executive not below the rank of secretaries to the Government of India. So now what will happen? These 3 members who are part of the search committee will identify the suitable candidates and they will make the recommendation to the selection committee. Now the selection committee will select the people and will make the recommendation to the President, and President through the order of the President under hand and sign shall appoint the person. So that is the process. So now this new law has introduced few more another thing. According to the Constitution of India, qualifications has not been prescribed. So now what happened? This particular law prescribes some qualifications to the election commissioners, and it says that the Chief Election Commissioner and election commissioners shall be appointed from amongst the persons who are holding or have held a post equivalent to the rank of Secretary to the Government of India. and shall be persons of integrity who have knowledge and experience in the management and conduct of elections. So what has been done? 3 points has been done. One, an essential condition, that is Secretary to Government of India rank. So that should have been a minimum condition. One another, a person of having integrity, and the third condition is experience in the conduct of elections. So now something which was absent previously has been introduced. 3 conditions, starting with the person should have served as at least Secretary to the Government of India, person should have integrity and experience in conduct of election. So in my personal opinion, I would say the first, these two, experience in conduct of election and integrity, is very necessary for an election commissioner. But a rank of Secretary to the Government of India, see, there can be accusations. I am not saying that there can be possibilities, but there can be accusations of conflict of interest, because a person who was already part of the government, if the person is again appointed to an entity which is supposed to conduct free and fair elections, how will the society perceive it? So that is one challenge which is being placed upon this particular act and this particular section 5 of the new act. So that's it with respect to the qualifications. With respect to the selection committee and search committee, we have seen what happened. Now comes the thing which is being there in the current affairs. Can the parliament actually do such a thing? When the Supreme Court of India had already made a judgment, and when the Supreme Court of India had already said that the third member should be a neutral entity, that is the CJI, can the Parliament of India replace that section? That is what we need to know. That is where people should have a clarity upon whether the Parliament can do such a thing. Here, a close examination to the judgment is necessary. In the judgment, under point number 126, it was clarified that until the Parliament makes a law in consonance with Article 324, we have seen that Article 324 gives power to the Parliament to make the final call with respect to qualification, appointment and all these things. So the judgment also, Anu Baranwal versus Union of India judgment also says that until the Parliament makes a new law, the Chief Election Commissioner and Election Commissioners shall be appointed based on the recommendation of a 3-member committee that comprises of Prime Minister, Leader of Opposition and who is the third person, that is the Chief Justice of India. So that was the judgment given by the Supreme Court, which means until you make a new law, our judgment shall prevail. And when you make a new law, your law will prevail. That was the judgment given by the Supreme Court. Looking in this particular angle, looking at this particular clause as part of the judgment of the Supreme Court, Lok Sabha and the Rajya Sabha, when they were passing the law, they did not make any mistake, because they only did what the Constitution under Article 324 and the Supreme Court through Anu Baranwal versus Union of India did. They never did nothing extra. So that was what I was wondering. What did the Parliament do wrong? They have only done what was permitted through the Constitution and the judgment. So now let us see through the cases, the development of the cases, what will happen in the future. Whether the Supreme Court will overturn their judgment which they have already said, or whether they will quote this particular statement and say that Parliament had all authority to do these things. Thank you.
Amrita IAS Academy.